All right. So introducing our speaker for today, Carrie Frias. She's managing partner for Frias Indian Law and Policy LLC. She has over 10 years of legal experience and currently serves as managing partner at the firm founded by her husband, Indian law attorney Richard Frias. Carrie's expertise lays in trademark, copyright, and the protection of indigenous and intellectual property. And then she also engages in Indian law, general civil litigation, and cross-jurisdictional issues. So she's really, really great too. And we're really happy to have her here. So please help me welcome Carrie for our final speaker today. And I am so eager for this presentation. So Carrie, let me turn the floor over to you.
Thank you. Hi, everybody. Sorry, I'm coming in a little fuzzy. My name is Carrie Frias, and like Raquel said, I am the managing partner of Frias Indian Law, which means my partner in the business is my husband, and for the first time, we're working together in the business. So he likes to say I'm his boss all the time now. So I'm his boss at work and at home. Um, so makes it fun for me, maybe not so much for him, but we've both been working in Indian law for a long time. And so my goal today is, like Holly was saying, the legalese and it's kind of the part of the business, I think, like also Jeremy was talking about yesterday, where you kind of just want to ignore it because one, it seems really boring, and two, it's very detailed and they use a lot of legal words to try to make it difficult to understand. And my goal is just to provide information. I believe knowledge is power. So whether you use any of these intellectual property rights and registering your rights in planning for market, or if you don't, it doesn't matter. What matters is that you have the information and that you can understand it. So I'm not a super great multitasker, but I'm going to try to observe your questions as they come up. And please feel free to ask. And if you don't get a chance now, you can always email me later and ask me a question, and I'll do my best to answer. But let me see. I'm going to share my screen and see if we can get started. I think it's going to be hard to match up to the excitement of the other two presentations. I got to tune into Jeremy's yesterday and it was great. I'm going to try to make this as exciting as possible, but again, it's kind of some of that like icky stuff that you don't usually want to deal with, but I find it fascinating. So hopefully you'll get something out of this. So I tried to look at this as protecting your intellectual property rights and just sort of knowing what they are when you're going into market and about your brand. So we want to protect our intellectual property rights, and my goal in my firm is to protect the intellectual property rights of my native clients, who are usually small business owners. If you see on the left, that is my husband and I's logo for our firm. And so I just put that there as an example of kind of your logo or your brand that you're trying to promote. And I have my contact information here, and I'm happy to provide it at the end if you all have any questions you don't feel comfortable asking. So just to frame the discussion, I like to start off with this quote that I found. It's actually from an article written by, oh my gosh, professor at ASU. Her name will come to me in a minute, but she's wonderful. So I think this just kind of frames what we're talking about, and I'm going to read it, not because you can't read it yourself, but just because I think it's like really powerful statement. This is a statement by Walter Echohawk. He's just saying that the theft of culture is part of a one-way transfer of property from indigenous to non-indigenous hands, basically seen in colonizers doing it to around the world. And it includes not only the taking of land and natural resources and personal property, but even the heritage of indigenous peoples. And he says, plucking them as clean as a Safeway chicken. I don't know why, I just love that line. Securing adequate intellectual property protections for the cultural rights of Native artists and tribal governments, so the artists are you all, remain central to the recognition of human rights. And really powerful. It's, you know, the final phase of colonialism will proceed unabated if we don't do this. So for me, what that means is like colonialism has taken away land and attacked culture, and the last remaining, not the last remaining thing, but the thing that we have to left to like protect the most is our native intellectual property, right? So that's, I'm not saying it very well, but that's the kind of remaining thing that we have to protect, that the protect from colonizers and settler states. So I just think that's a really powerful way to think about it. And I know you all know this because that's why you're here. And I'm sure you've had experience with people trying to steal your artwork, trying to borrow things from you and then making money off of it. And so it's really painful though when it's non-Indigenous people stealing, you know, your cultural heritage and your intellectual property. So I like to set the scene with that and frame it that way. Okay, so just starting to think about your intellectual property rights. So you are all artists in some form or another. And as soon as you produce a piece of work, a play, pottery, anything, you have intellectual property rights that immediately attach to that under the Western system of law. And so I kind of think of it in three different main categories, and it's simplifying it a little bit, but this is how my brain thinks about it. There's copyright, trademarks, and patents. So these things, like a copyright exists, but in order to have protection under Western intellectual property, you must register those rights to protect them. And it ensures that you have proper legal ownership over your intellectual property, but it also ensures that you're preventing other people from stealing your work. So I'm not going to talk about patents today because that's sort of a different level, more with like inventions. It could be like a patent for like a drug. There are design patents like for clothing and things like that that are important, but in the world of law, you have to have another specialization and examine that to be a patent attorney. So I'm going to stick to what I know, and what I think is most useful to you all is copyright and trademarks. So that's what we're going to focus on today. And I tried to strengthen up my copyright section after hearing some of the discussion yesterday. So let's get started with that. Copyright, and just what I say here, it protects the original work of an author, and it protects a variety of different types of art. When you create it, you have it. And that little C symbol with the circle, I always wondered like why people were putting that everywhere. And it actually indicates your ownership of the work. And as soon as you create it, you own it. Okay. And here's the like icky legal definition of it. But I'm going to break this down. So copyright is an artistic, literary, or intellectually created work. So it can be a novel that you wrote, music that you made, movies, a code that you developed, photographs, paintings. But what's important is that it's original and it exists in a tangible medium. And what that means is original, like you created it and it's on like paper, canvas, film. It can't be just like an idea in your head, right? That we can't, you know, in the Western world, we can't name that, or so it has to be some kind of tangible medium, like something you can see, hear, touch. The second part of it is that the copyright protects your exclusive right to reproduce, distribute, and perform or display the creative work. So that's where once you produce the artwork, you have these certain rights that we call it in law that attach to it. So, and those are special intellectual property rights that you own. The second thing it does is it prevents other people from copying or exploiting. And I think like let's focus on that word, exploiting your work without your permission. So it's very important. And in the legal world, you know, I would kind of stress trying to register your copyrighted material, especially ones that you think are more open to getting exploited or copied by other artists, or even just somebody stealing your artwork and putting it on a bunch of t-shirts and selling it and making money. So I try to pick out examples that would be relevant to you all. Like I'm trying to think like when y'all go to market, what can be copywritten? So sculptures, again, photographs, pictures that you take. So graphics, like if you're a graphic designer, fabric designs, this is weird to me. Okay, fabric designs and patterns can be registered for copyright, but not the actual clothing item. So I think Jeremy yesterday was talking a lot about like his designs. And if you have a certain design or pattern, you can register that for copyright so that someone can't come in and claim it and reproduce it and sell it and make money off of it. I see someone's developing a nonprofit too. So I've worked with some nonprofit organizations and I registered their copyright for their logos, or another organization, they had some film that they showed on their website or some drawings that some artists had done for them, and we registered those copyrights. Someone asked a really good question about global and regional copyright. So so that's a thing I'll get into. And yeah, Tahada, I'm saying her name wrong, but Atone, she's a wonderful attorney too that does this. If you're a blogger, blog posts. So I just want you to stop and think right now and maybe put in the chat like what you create that you think might have copyright registration potential. Because again, there's the difference between when you create it, you own the copyright no matter what, but you can't enforce your rights if you don't register it. It's difficult to, right? You can tell someone to stop using your artwork, but there's nothing legally you can do if you don't register it. And if you register a copyright, the really nice thing is that they've now sort of made it easier to, so you used to have to go to federal court to enforce your rights, but now they have like an administrative body within the Copyright Office that can do this. So one that's going to be cheaper and probably a little bit faster too to get your, you can actually get money damages. So that's one thing. So do you guys mind just putting in the chat something that you create that you think could be copywritten? And I see Jeremy's talking about NFTs and blockchains. Yeah, that is like the new emerging area too in copyright, is like AI and how the Copyright Office is going to deal with that. And definitely something I need to get up to speed on, because they're trying to tackle it as the US government, like how are we going to deal with all this? But so just think about sort of what you created and what you bring to market that could possibly be registered as a copyright. I'm gonna go on. So who owns the copyright? And I just put this in its own slide because I think it's really important to reiterate. You as the author of the painter, the sculptor, you own the copyright as soon as you create the artwork. And so just keep that in mind, you're the copyright owner. Okay, and we went over this just a little bit. So what that means is you have these rights. You have the right to reproduce it. You can, like, let's say you made a painting, right? You could prepared derivative works. Like, what is that? Like, you can make like smaller sizes of your paintings. You can make a bigger size. You could put on a t-shirt. You can copy your work and give it out. So if you had a book, you could produce multiple copies of the book and distribute it, sell it. If it's like a play or something, you can perform that work publicly. You can display it publicly. And again, you can perform it if it's an audio, like a song or something. Sometimes people also like may record elders talking and telling stories. I believe that would fit in that category too. So just want to touch a little bit on what Jeremy was talking about yesterday with licensing. So when you if you transfer your copyright registration to somebody else, you're giving up these rights, right? And allowing that person to do it. But what Jeremy was talking about, licensing is like kind of like a step down from that. So you can license or allow someone to do 1, 2, 3 of these different things. So you could license someone and allow them to reproduce your work. And of course, you would have an agreement in writing where you would make money off of that. And I think that's what Jeremy was doing and talking about yesterday. So that's really important. So these legally under US law, this is what a copyright registration will give you. Not give you, it's the rights you have. And let's see. So I touched on this a bit. You can transfer those, that whole bundle of rights, you can transfer that. But it has to be in writing and signed by you in order for the transfer to be valid under law. So, and I tried to think about like, if you go to market, right? And someone buys your, I'm sorry, painting just keeps coming to mind, but I know there's lots of other things. If someone buys your work of art, they don't own the copyright. So when you sell that piece of work, you're selling the physical object, but not the copyright, not all those bundle of rights under. The only time this changes is if you're an employee or you're contracted to do some work. So let's say some of you might be graphic designers, right? And someone contracts you to do a logo. Usually within that contract, it'll say that those intellectual property rights, the copyrights, are transferred to the person who's contracting to do the work. That's why it's really important, if you are engaged in any of this, to have someone that can look it over. I, of course, recommend an attorney. It doesn't have to be me, but just having someone to look over that, so you make sure that you're not getting like the bad end of the stick, that you know which rights you're transferring if you produce a piece of artwork for somebody else. Also, if you're an employee in a company, and this is a simple view of it, it's much more detailed, but if you're working in a company for someone, usually anything you produce within that relationship is owned by the company. So that's something else to think about. Even if like you're on your break and you're working on some artwork for another client, but you're using your company's computer, in some cases that can even be considered that your employer owns the work. So it's just something to be really cautious about, and also just to be knowledgeable. Know that like when you see these independent contracts that are having you make something for somebody else at a price, just because someone buys it, pays for your work, doesn't mean that they own it unless it's in writing in that contract. So I think it's important for artists to understand that too. And I know this is kind of like, for me, it's kind of like some heavy stuff. There's a lot here, but I think you don't have to understand it all. You just have to like pick up on the pieces that, like, when you go to market and you sell, you're just selling that object that you created. And unless you write something down with the person, you're not selling your copyrights to it. So just want to take a moment before we delve into another area. Does anyone have any questions just at this point about copyright and just what I went over? It's a lot, I know.
I think there was one, and it's more in the sense of like, I guess if anything, if you could bring a little bit to light about what could copywriting take form of, if it's not just like imagery, is there like I know that you listed some examples too, but for like companies that are essentially like more service based, is it predominantly that they just like work within imagery of their of what they get copyrighted, or is there anything else that you've seen as a commonality that is a good practice for them to consider getting copyrighted?
So it is, so we're going to talk about trademarks next, which is more like branding, logo, what identifies you and your business. Like again, my logo here on the right, but copyright is definitely something that, so it's limited in the sense that it has to be like something tangible that you produced, like that sculpture. Again, like an idea can't be copywritten. I'm trying to think of, I guess I don't like off the hand have something all the way around because I'm not sure exactly what everyone is doing, but like in thinking about like Jeremy's presentation yesterday, like the designs on his t-shirts, right? Those are eligible for copyright registration. I would think like some of the designs in his watch bands, and I remember that because I won one. I was like, I like those. I need one. Maybe some of the images on his shoes that he made. Any of the paintings, again, like the patterns for his clothing
Yeah.
line that he did the fashion show for. So does that help? Is that
Yeah, I think if anything too, maybe this leads to another question for our first speaker that was on, or like the, I guess sheds light on something that's like, of JT's work, like how he talked about his designs of his necklaces that he had that were priced. Could you essentially like copyright the, I guess like the design of jewelry like that? That's not so much of like image, like graphic design place, but could you copyright like a beaded earring or something like that? Is that possible?
so not necessarily the earring itself, but I would think, and I've encouraged, I have a client who makes jewelry, and I've encouraged that client to try to register a copyright on her designs. Like she kind of sketches them out beforehand, right? And so I've encouraged that person to try to register the copyright for that design because she'll reproduce it in different colors or different, but it's all the same pattern, right? And
Yeah.
so we've run into where somebody else is using those patterns and selling their own jewelry who's non-native, right? So what I've recommended to her is like, that design that you're using, let's go ahead and register that as a copyright. I have another client who's fashion designer who actually got a patent for one of the designs of their clothing. So I think that's one way to do it. Like my goal is to try to use sort of this Western system and figure out like how can we massage it to make it work to fit and protect what Native artists and business owners are creating.
Yeah.
So I think it's like a conversation, and that from my experience, that's what I've tried to do to help protect those. I tried to get a design on a shoe protected, and shoes are a little harder just because of some case law around that. So I didn't get that done, but it always comes down to like how much you want to fight it and how much you want to sort of fight the US copyright office on it and how far you want to go and push it. I of course like to push it, but that also requires funding and money to do that. I think someone else had asked about like global protection. So US, right now, what I'm talking about is US law. So it only offers protection within the US. But that would be interesting because like when you go abroad, and I'll talk about that with trademarks a little bit. Somebody asked,
Yeah,
was
there's
it
a lot
Navajo name? Okay, well, I'll try to get to some more of them at the end, but I'm going to talk about sort of that global national issues with trademarks a bit more. If that's helpful
Yeah.
too.
No, definitely. And I guess like just as a recap, copyrights can't really pertain to too much of like a process, and it's more essential of like an actual thing. When we say tangible, we mean something that we can essentially kind of like almost touch, feel, see in a way.
Yes, yes.
And that's where it's extended into the digital realm of stuff. It's not so much of a process of something, but instead it's more of like the end product, the final and like what it becomes essentially at the end, right?
No, you nailed it. So like the process would be more for patents. Like if you're trying to protect a process or like a trade secret, like you know, the formula for Coca-Cola, right? That's a highly protected like trade secret. So though that's I say higher level because you need to have like specialized legal counsel for that.
Yeah.
With copyright and trademark too, you don't have to have an attorney file the registrations for you. I've actually been pondering doing like kind of a video of how to do your trademark or your copyrights so
Mhm.
that people can easily register them.
Mhm.
Um, it is good. So when we talk about trademarks, you also don't have to have an attorney if you're a US business person, like you're not a foreign person. But trademarks can get a little more complex and they're a little more expensive. So, you know, I always recommend that clients try to work with attorneys on that. But patents, you have to have a specialized attorney. Trademarks and copyrights, you don't have to. So I think that distinction is important to make too.
Awesome. Yeah, thank you so much for that clarification. But yeah, everyone, I'm logging all of these questions and we'll ask her at the end to go through some of these. But I'm sure some of these questions that you guys are having will pertain to this next section of trademarks that Carrie
Yeah,
has. Thanks so much, Carrie.
you're welcome. So trademarks is where I have most of my experience. And, you know, I'm trying to delve more into the world of copyright because I think copyright can be more affordable, more accessible, and sort of a faster process, which is important for small business owners and artists, native artists. Trademarks is a little more expensive. It takes longer. And then you go to the next level of patents, right? And patents is the most expensive process. You definitely have to have a specialized attorney. So it costs more, it's a longer process. So I see it sort of as a stepping stone, right? So next we're going to talk about trademarks. And what I want to talk to you about is registering your mark, monitoring it, enforcing your rights, and using it consistently to protect your brand and reputation. Um, so copyright or trademark, got my, on to the next slide. So trademark is a way to distinguish your brand and associate it with your company in the certain area that you sell goods or sell services. And the whole point of copy or trademark is that the U.S. law is based around not creating market confusion. So they don't want customers. The whole point of the law and the way it's geared is that they don't want customers to get confused if there's a similarity between marks in the same service area or goods and services. So I think it's easier as I show examples, at least it's easier for me to learn that way. So I'm going to just kind of dive into it. And I think it'll make sense as we walk through it. So one of the questions is, do any of you have a logo for your brand? If you guys see in the Change Labs one, the different colors, and I want to say the mountains would be their logo, right? So are you guys currently using a logo for your brand? And one of the important things, and that I think sometimes people miss, is that you have to use it consistently. And it should be on your web page, like everywhere you look. I should kind of like see your brand associated with your products, because that's how you're identified. This picture I have on the right, this is a company out of Choctaw Nation, and they are a chocolate company, and they make the most delicious chocolate. And that's just a picture of it, but the circle with the bedra, that's one of their words in their language. That circle with the design in the handwriting, basically, that is trademark. That's a registered trademark for their company. So the idea is that when you see that circle with that name, that you think of Choctaw chocolate. And I definitely do, because I've tried it before, and again, I'm promoting it because it's delicious. So think about where you're using your logo, and if it's always attached to you and your brand. Okay, so what I'm going to talk to you about is there's two types. So in trademark law, there's two types of things you can protect: your design mark, which is usually your logo, and then a word mark, which is maybe the name of your company, the name of a brand that you're using. So again, I like to use examples because that's how I learn. One of my favorite Native-owned makeup companies, she's out of Canada, and it's called Cheekbone. So her design element, if you can see my screen on the left, is that C, that eloquent C. And the word element, the word mark, is cheekbone, right? So when she first applied for registration of this, she registered it all together. So that she registered it with the design mark, the C, and with the wording. And you can see, so when I say you have to use it for branding, you can see, I think this is like an eyeliner or something, but she has that exact image on her eyeliner there in the picture. So you're seeing that brand every time you pick up her product. And there's a little TM there. Just keep that in your mind. We're going to go through what that means in a minute. So again, her design element is that C, and then the word mark is their cheekbone. Okay, now we have another design mark. This is a fashion designer, and so this is from the USPTO, and that's why I'm using it. So B Yellowtail. So she registered, same thing. She did the design with B Yellowtail. She registered that whole thing. So again, we have the design on top and then the wording below. And she registered it in 2016 for clothing, dresses, skirts, tops, camisoles, scarves. So you can see like the cotton fabric above. And then if you look closely at it, it's a little hard because it's white on white, but you'll see in her packaging of her fabric, it has the design element and the word mark. So that's what I mean about branding. It's really important because in the trademark process, you not only have to show that, oh, Jeremy said he designed it. Oh my gosh, awesome. So you have one of the designers right here, but the owner needs to make sure that not only if Jeremy designed it, but that I'm using it in all of my packaging, because you have to prove to the United States Patent and Trademark Office that you have it and you're using it, and that you continue to use it up to 5 years and then a 10-year mark. So it's really important that when people see your product, they see that and they associate that with you. Okay, so word marks. Another brand, like skincare brand, that I think is neat, native owned, Sister Sky. So they have some design elements, but what they actually registered as their trademark is the wording, Sister Sky. And you see that R with the circle. And I'm going to talk about that in a minute. So that's really important. So they just registered the word Sister Sky. And you see that on their products too. GNU, it's a fashion line. I think they're mostly known for jeans, but they're from a couple tribes in the Midwest, or yeah. So what they did is, you see that's their name, GNU. So they have one trademark for the name GNU, and then they have, which is their word mark, and then they have another one for that, the leaf. You see the leaf symbol below? So they registered them separately. One is the word and one is the design. And when they originally did their word mark, they registered it for a smaller category of goods, like scarves and pants, like jeans. And now when they went back and registered the design mark, they registered it for a wider variety of things. So that's another thing to keep in mind. Like right now, if you're just selling scarves, right? But then in a couple of years, you decide to sell more stuff, then you can apply in different categories for what you're selling. So you have to think about it as making sure you're protecting not just, like for Jeremy, not just the watch bands he's selling, but the shoes or the clothing. So you have to, yes, exactly, Jeremy, you have to choose your categories when you're registering. And it may change over the years. You may not know everything you're going to be doing right now, but you can add onto it later by doing another application. Okay, so this is kind of just a summary of what we had talked about. What should you register? And I think this question depends a lot on both budget and kind of what you have and what you're selling. So you can register just the design mark, you can register just the word mark, or you can do them both together, like I showed you with Cheekbone, or you can do them both but separate, the way GNU did with their word mark and then their logo at a different time. So sometimes this depends on like how much money you have. Each category you apply in right now, USPTO is choosing, or it's $350 per class. So that is something to consider. So if you're, let's say you're providing graphic design services, but you're also, I'm trying to think, you're selling like some kind of clothing and that's all under one brand, that would be two separate categories. So there are some categories for goods that you are selling, like physical goods. And then there's another category for services that you're providing. So like a lawyer's services is in a different category. Education is one of the big categories that I use a lot. So people are providing education services. Okay, let's see. So why should you care about trademarks? And you already do, or you wouldn't be here, but I think I just like to point out this case because it's a famous one and it's very egregious. So it's easy to like, oh my gosh, you know, how could they do this? So Navajo Nation actually filed a lawsuit against Urban Outfitters, and you can see they made these hipster panties, and they're called like the Navajo panty, and this Navajo flask and this Navajo shirt. So they're calling everything Navajo. Now they filed their lawsuit under several different laws, one of them being the Native American Arts and Crafts Act. But the one that I'm talking about in this presentation is trademarks. So they filed because Navajo Nation has a collective trademark for the word Navajo. And if you are a Navajo citizen and you're using Navajo to sell your products, that is okay because it's owned collectively by the tribe for tribal members and the government. But if you're non-Navajo and you're using it like Urban Outfitters is, that's infringing on their trademark rights. So this is the other side of, you want to protect your brand so that it cannot be used by others and confuse them. So what they argued in this case is that Urban Outfitters is confusing the customers by letting the customers think that maybe Navajo designed these products or approved them. So it's twofold, right? You want to make sure you're not infringing on someone else's trademark rights, but you want to essentially protect yourself from someone like Urban Outfitters doing something like this to you. And ultimately, the case was settled as to where I believe Navajo Nation can license certain things with Urban Outfitters, but it's good because Urban Outfitters needs to get Navajo's permission to do that. So this is a really cool case that I'm sure many of you already know about. This one may be less so. So the Lumbee tribe, North Carolina, this on the bottom is their tribal insignia. And the yellow part is what they have, like, this is from their website, right? So that's their insignia, their logo, that's a registered, so tribes can register their insignias in the database, the trademark database. Then Budweiser went ahead and in one of their convenience stores near the Lumbee tribe, they did this really not so nice display of their beer, and they have the same wording on top. You can see Heritage, Pride, and Strength, Lumbee Tribe of North Carolina. So this confuses the customer because when they're going in to buy a Bud Light, they're thinking that somehow the tribe is like, it's the tribe's beer or the tribe's associated with it. So it's causing what we call market confusion. So Lumbee sued Anheuser-Busch in this case. And Anheuser-Busch, right after the lawsuit was filed, they took this down. Obviously very offensive to the tribe. Let's see what else we have. I like pictures, guys, because I can only look at words for so long, but so these are just some examples. I know I'm like preaching to the choir here because you guys get this, but sometimes it's so egregious that you just have to point it out. And so the one we have here on the left, Crazy Horse Malt Liquor, has nothing to do with Crazy Horse's family or anything like that. It's a company that's producing and it's malt liquor. So one, may be a bit offensive, and two, has nothing to do with the actual Crazy Horse. Two, this is very near and dear to me, the Zia symbol, and I'm sure some of you are from New Mexico, right? This is the symbol that's on the New Mexican flag. So, but it's also a very sacred symbol to Zia Pueblo, who are the ones that had it. Zia has attempted to register this as a trademark, but they cannot, and their application was rejected because it's on the flag of New Mexico. And it was submitted for the flag in the early 1900s by an anthropologist's wife who her husband had found it on pottery or something, and she submitted Zia's actual symbol to be the flag. And so now the Pueblo of Zia has no ownership rights over their own logo, trademark. And if you see in New Mexico, I mean, the symbols everywhere. It's on earrings, clothing, everything, you know, you can buy, you can see the Zia symbol, and it's just it's a sad point. Like the tribe could have actually been the ones making money off of that, but instead, you know, in my mind, the state basically stole their symbol. And then lastly, on the right here, we have Aloha Poke Company. And this is actually a restaurant. I believe it's in Chicago, and they're using Hawaiian words, and I believe making Hawaiian type food, but they actually sued Native Hawaiians in Hawaii for using the same name when they're non-native and they're producing a product. And it causes market confusion, because you would think if you're going there that you're getting, you know, authentic Hawaiian food made by Native Hawaiians. So those are just some examples. Another one that I think might be relevant to this group is a lot of companies sell Hopi corn, and it's not anything related to the Hopi tribe, but they're selling it, and I believe that, again, that causes market confusion because people think they're buying, like, you know, real Hopi corn, and Hopis are not making any money off of that. So a lot of vendors and stuff sell this Hopi corn that, again, like from my point of view, I'd rather see the tribes and the individuals making money off of this, whose symbols and logos are being used by non-natives. Okay. So again, I promised I would go over this. So my kids are total dorks, and like they look on packaging for these symbols now, because I guess I've talked a little bit too much about it at home. But so, and it took me a long time to get this, because you see these symbols everywhere, but what do they actually mean, right? So on that one, I think it was Sister Sky that I showed you, it had the R with the circle around it. That means that you have a good that you're selling that's been registered with the United States Patent and Trademark Office. So that's kind of like a warning to others, like, don't touch this, don't try to take my logo, my word mark. I'm registered. And when you get that registration, somebody had asked about this in the copyright context, but in the trademark context, you can get local registrations within your state, but if you do it with USPTO, you get national. So it's cross the country protection. So that's how I like to think about it. If you see the TM with the circle, a lot of people use this, and I don't think they know what it means. You saw it on the cheekbone. Cheekbone, I believe, is now registered, but if you've applied for a trademark registration for your logo or your brand name, you can put this symbol afterwards, because it's kind of letting people know, like, I'm in the process of applying for a trademark. And the one on the bottom is much less used, but it's the same thing as the R with the circle, except this is a service mark, like the legal profession or an education service. So it just indicates that you have a registered mark that's, you're not selling goods, you're selling like a service. So I think those are important. And you can't put the R on your logo or brand or word mark until you've actually gotten that certificate of registration from the United States Patent and Trademark Office. The TM, you can put that on as soon as you apply. And then the same with the SM, you can't do that until you get that. They used to send hard copies of the registration certificates. Now they just said electronic copies, but when you get that pretty electronic copy, then you're good to go with this. And I look at it as like a warning to other people not to try to take your stuff. Okay. So this is the part that always kind of gets me with explaining to clients in thinking about whether you would want to apply for trademark protection for your brand. And if you haven't developed a brand yet, or you're in the process, one thing to think about is USPTO, like again, I told you I like pictures and graphics because they make more sense to me. But if you look up at the top on the red of the strong ones, USPTO loves things that are fanciful and arbitrary. And what does that mean? It's like kind of like a made up name for something, right? I think like Kodak, or like it has no relevance to your actual brand, but it's just what you call yourself. Those are the easiest to protect because they're the most arbitrary and kind of different. USPTO loves that. That's good. It can be suggestive of what you do, but the less suggestive it is, the better. If you have a name of your brand that actually describes what you're doing, again, we're getting, that's not as good. And if it's super generic, like commonly used, and you can't really claim any, it's not individual, it's not unique, then you're probably not going to get protection for that. So that's what, so the more unique and arbitrary your brand and your design is. Design marks, by the way, are much easier to protect than word marks because it's less common to have a similar design. And I find with native clients who are doing design, even that to be more true because the designs are so intricate and have meaning. And if it's not like a super generic design, then you're likely to get that protected. And sometimes that's advice I give to my clients who might have a more generic name, is to try to protect the design mark then. So I hope that makes sense because that took me a bit to grasp. So for instance, I would have a really hard time protecting my name, Frias Indian Law, because it's my last name and they consider that like more generic. So I would protect this logo that you see here instead. So that's kind of an example of what I was talking about. So I know I've thrown a whole lot at you, but I appreciate that you listened and you know that you're taking the necessary steps to protect your brand, because I think it's really important, even if you're just thinking about it now. Like, that's good. That's great. And I'm happy to like answer questions now. And if you don't feel comfortable asking in this forum, you can text me. That's my number there, and that's my website and my email. You can ask and I'll do my best to get back to you. But I know that, again, that was a lot of like a lot of material. So I do my best to try to answer any questions you guys may have.
Yeah, awesome. Thank you so much for that. I feel like we know a lot more about each one of these just because like I think I've heard them so they've been used interchangeably and it can be very unknowing of which one actually is kind of right for your business, or even to again like why people get denied and you know, items like that. And so I want to go back to a couple of questions earlier in the chat, in which there was one about, hold on, just get into it real quick. It was like how to enforce it. I had a conversation this morning, actually, ironically, with another attorney, actually a professor at ASU, Trevor Reed, about this exact topic about enforcing a copyright. Like, so what can you do when you see someone, say in market, say you walk around Swaya and you see someone using a design that you've used before or you've copyrighted yourself? Or trademarked. What are some steps that people can take to essentially enforce it, or who do they go to do so?
Super great question. And so that's where, especially with copyright, you need the attorney, right? If you don't use an attorney to do your application and stuff, fine. But when you see someone infringing on your rights, or the other side of it is, you know, I've had clients who got letters from other companies saying, hey, wait a second, you're using my material either in trademark or copywritten. that's when like you need to find an attorney. And the first step that I always take, and I think it's the same for most attorneys, is that we would write a letter on your behalf. And usually, not always, usually that has a stronger effect on someone who might be utilizing your designs. So in copyright, you can do that, and you can tell them, and the attorney can tell them in the letter, like, here's the law, and here's what I can recoup, basically, if I have to take you to court. And so the attorney can help you like negotiate with the other parties so that, not all attorneys are like this, but I'm like, let's try to avoid litigation if we can, because litigation is costly for both parties. And I've never seen where litigation ends with one party happy, even if they win. So, you know, so usually it's like a letter writing to start out with. And that's also for the attorney to kind of to document what happened, what law they violated, and try to negotiate with the party. And like I said, under copyright, at that stage, it's a little easier to, if you have to be able to prove that, the other person is making money off of your design for it to really be worthwhile to litigate. But so I think at that point, it's really good to find an attorney. In trademark, the same thing. Usually the attorney, we call them like takedown letters. So if somebody, I had one client who I said the jewelry designs were being copied and posted on social media. So at that point, the attorney can write a takedown letter. The sort of bad side of it is, I guess, with technology and people being on social media, a lot of times those letters get posted on social media too. So a lot of attorneys try to take like a gentler approach now with those, and I guess not be as formal, because you don't want to create bad publicity for your client around that too. So when you ask someone to take it down, like, hey, different people have different approaches, but that's one of the sort of consequences of social media in this regard, is that even those takedown letters can be used sort of against you. So that would be the first step. And I mentioned this a little bit before, but with copyright, I think it's both bodies, the Copyright Office and the Trademark Office, have administrative forums that you can bring any infringement items to. The thing is, it tends to be more expensive with copyright, because basically the administrative board that they have is like a court, and so you're litigating. I mentioned that the Copyright Office used to have to take all these cases to federal court. They just last year came out with administrative body that can handle some of these. And I think in copyright, it's a little easier to enforce. But again, like, you need an attorney for both of those steps, because you're filing documents in an administrative court, administrative body. And they can be expensive. And that's why small businesses need a good attorney, because the bigger businesses will, even if you don't see it as related, they'll go after people who they think are even marginally using their materials or their trademark. So, yeah, that's a long-winded way of explaining it, but hopefully that's helpful.
Yeah. And speaking of which too, because I feel like a lot of artisans, take Jeremy, for example. Should we keep going back to Jeremy, and his wonderful designs that he has? If they have multiples of designs that they're copywriting, I think Jeremy kind of spoke to this, that he had individually essentially copyrighted each one of them that were predominantly used in his stuff. So like, for example, if Change Labs copyrighted their logo and then were essentially printing it onto like cups and things like that, would they have to individually copyright every single design that they print on cups so that it's essentially protected? Would that be a good way of practice, or would that just kind of be a little bit more extensive because it does cost every single time to submit a copyright.
Right. So once you protect the design, it doesn't really matter like what you put it on. So, and what I often advise my clients, especially in the trademark, is like if you see my logo on this page, it's in color. But if there's not a strong attachment to the color, and all I mean by that, like sometimes color is really important to the brand owner. For me, it is a little bit, but ultimately it doesn't matter. So what I would do is, what I advise my trademark clients is to protect this in like black and white, like without color. That way, any color you put it in, it doesn't matter. So as long as like this design is protected, then in black, like without color, then it offers you greater protections. And so that's one thing that you can do to help with that, because you're right, even the copyright, it's cheaper. It's about $40 an application, depending on what you copyright. And it's a quicker process. So trademarks can take like up to a year from beginning to end. And that's if like you have no problems. So whereas copyright can usually be done in 2 months if you have no problems. So it's just all these things to keep in mind. But even like $40 an application, there's other ways to get around that. Like if you have unpublished work and it's the same author, you can do like a grouping at a time, which will help save money. But yeah, I think if color's not important part, and you can do it in like a grayscale or just without color. I know I'm not an artist, obviously, so but without the color in it, then that can offer greater protection.
Great. So we're touching so much on this like kind of digital age, especially with like AI kind of being into the conversation. Especially, I recommend everybody if you're new to AI tools, to check out the session that Heather and I did on AI tools, especially around how they can either help your marketing or even to digitally design things if you're not an artist and need a little bit of help.
Yeah.
But at the same time, it does get into that gray space of, what, again, tangible copyrights, tangible trademarks, and things like that. So one of them, especially with more of an influence of wanting to build technological businesses, could it be possible to copyright code? Like if someone is building an app, is that more of a patent, or is that can codes be trademark or copyrighted?
I don't think that falls into trademark, and I would have to look at it like each specific example. That's like a lawyerly answer, right? But that sounds more like patent to me. But there has been so much on AI, especially with the copyright board. And one of the things they're doing now is like you have to identify if you used AI in your design. So, and it's coming out so fast that I don't feel like I'm up to speed on it as much as I want to be. So because it's just such a moving, like the board's having to adapt to that, right? And there's all these fears about AI. But I think with copyright, I know that's one of the ways they're trying to address it, is to have authors, artists identify when they've used it.
Got you. And then so like if I were to build a website and like I built it from scratch, like with the code, all of that code would essentially, it would be easier for me to essentially patent that code versus like trying to copyright it of the website completely. Right?
So
Sorry.
no, it's okay. So you can do aspects of your website and register them as copyright, like the blog posts. I'm trying to think, like the designs that you use on the website, the logos. You also want to be really careful when you are designing your website that you're not using somebody else's registered copyright material in your website. So you're using stuff that's in the public domain and not things that are somebody else's, because that can also get you into trouble. But like you can register the copyright of the photos you put up. Like if the photos are your photos and you're putting them on your website, you can register those. The videos, you can register those. Like the sound recordings that you do that you might put up on your website, those can be registered. So I think, to me, that would be an easier process to do that type of thing.
Mhm.
Like in more of a piecemeal way. That would be like my suggestion. Like the things that you produce that you put up on your website, to register those are available to the public, right? And that's where people can get stuff and use it. And a lot of times it happens in the social media space. So I would think most of the things that you have up there, you want to have protection for if it's your original work.
Hmm. Great. No, thank you so much for these answers. I think I went through everybody's questions in the chat. So if anybody has any more, I'm looking there right now to make sure we didn't essentially miss anybody's. But feel free to unmute yourself and ask and join the conversation as well. But yeah, this is a great session. I think if anything, intellectual property, copywriting, trademarking, patents, all of those are like they feel there's almost like essentially a consensus that you need to have money to go any of these processes. And that's what it feels like such a huge barrier to rural native businesses, because there's almost like you keep talking about having a really great attorney to be on your team to do this, where some of us, like or majority of us, come from like communities that don't really have that social capital to turn great attorneys, or even to just be pointed in the right direction. I think I was talking to an attorney this morning that there's only 9 intellectual property indigenous attorneys currently right now who are practicing, and majority of them are in academia. So they're teaching the up and coming next generation of lawyers, but they're not exactly able to go into the court process and go to a court session and things like that.
Yes.
So, it's
Yes.
huge need.
No, you're like hitting on something. I'm actually supposed to have a conversation with Professor Reed about this. And I always like to state this. So I have an Indian law firm. My husband is Native. I am not. I've been practicing Indian law for a long time. But you're right. There are very few practitioners, one that understand both like Indian law and so you could like get a law firm that does really good IP work, but they may not have no experience working with tribes or in tribal communities. And then you add the other layer of being a Native American attorney doing that on top, and like, yeah, you're running out of people, right? So that's important. And the other thing that you brought up that I'm actually wanting to talk to Professor Reed about is like, it is still like a lot of money. And then my argument to people is that your brand is like the most important thing. Like if one day, thinking in that Western mindset, if you sell your company or your business, you grow your business so big and you sell it, what you're selling is, and what's of most value is that brand that you've created, right? So registering your trademark is so important. But who has like 3,000, 4,000, however many people are charging like right up front to do that when you're starting up? And my business is a small business too, so I understand. And that is like the bread and butter of what I like want to talk about, because there are some organizations that will provide money to small businesses to like hire an attorney to do that. Some small business owners I've talked to have just done it themselves and like cross fingers and hope everything goes okay. The problem with that is that trying to fix an application after it's been filed and there's a lot of like mistakes and stuff is really hard, and then it ends up being even more expensive. But how do we create like that kind of like fund for like well-trained attorneys to do this kind of work for people who may not have the access to capital that you discussed? And that's kind of at the heart of like I don't know, all the conversations in my head that I'm having right now, and that I hope to talk to Professor Reed about. But I'm like super open to ideas that people have on that, and like how to overcome that barrier and provide these services without expecting people to put up so much money up front. And that's why I say, oftentimes I'll tell my client with a copyright, like, I'll do the first one for you, and then you can learn and do them yourself. And then you come to me when you have a problem, like I said, down the line with like infringement or that. Um, and again, you can do your trademark registration application without an attorney. It's just, there is a lot of law behind it. And if you get something wrong, sometimes it's hard to fix it. There's a really great attorney, excuse me, at USPTO, Susan Anthony. She works on a lot of the trademarks that like tribes file, but she's really great. And she just started like consultations with tribes on the trademark process. So there's some like really good people out there who are trying to help and do this work. But I don't have the answer to your question because I'm trying to figure that out too. But I am open to ideas because that is like, that's the problem, because we want to break down those barriers, not enforce them. So
Yeah. Yeah, no. I mean, I hope later on everybody in this Zoom room will be able to kind of see the network that we're building of attorneys, like all focused on helping and supporting Indigenous small businesses, because this is essentially a conversation that I've had with multiple attorneys about, the barriers of like just capital, of social networking, of reference and referring people, that we should come together and really kind of continue to have these discussions and conversations together about how we can make this not feel so intimidating, or not feel like it's a space that we should occupy or is open for us to occupy either. So it looks like there's no other questions unless someone's waiting for me to stop speaking. So if not, I'm gonna give it 5 seconds. No, unfortunately not. We were not supplying a free attorney. Again, as Carrie said, she's also running a small business. So yeah, but we'll look into some sort of maybe collaboration with other organizations to start this idea of how we can do better services. So great. All right, then. Thank you so much. I'm going to pass it back off to Raquel, but thank you so much for joining us this afternoon. Thank you so much to Carrie for this wonderful presentation and a wealth of knowledge for us to learn about more as we get prepared for going to market and putting up our booths and figuring out about collaboration and things like that. So thank you.
Yes, thank you, everyone.
Thank you, Carrie, for that awesome presentation. It was very, very insightful. And thank you for answering all of our guests' questions. Everyone be safe. We'll talk to you all later. And if you see us around, please grab us and say hello. And we'd love to talk to you about change lots. All right, guys. Bye.